in particular for the solicitors, that they can use it for their CPD requirement. This is just a refresher seminar. I did this previously in 2020, I think, where it was a more wide-ranging discussion, but in this seminar, I just want to give, I suppose, an introduction, set a context, and focus, I think, in particular on Section 150 and compliance with Section 150. What's prompted the seminar in a lot of ways is the completion of our recent Law Society inspection. We have had, since Callantansi came into existence in 2008, we've had now 3 inspections. The first was 08, the second was 2012, and this is our 3rd. So there's a 10-year gap between the current inspection and the previous one. So that means that, I suppose, this inspection and the report that we've got gives us a fairly good insight into the kind of progress that we have made in the meantime, and also the areas where we require further improvement. But overall, I'd have to say that the inspection has been quite positive, but I suppose the areas for improvement are always areas of concern, so we need to just focus in on those too. But I'll touch on those as we go through the seminar. So just to set the context for regulation in general and regulation of the professions, we're obviously part of the solicitor's profession. We're now co-regulated primarily by the newly formed Legal Services Regulatory Authority and also by the Law Society. So that means there's an element of self-regulation through the Law Society, and there's an element of external regulation by the new authority. To what extent that will impact on our lives going forward, it's hard to know yet, but I imagine the external regulation piece will have an impact, and it will probably be, possibly that solicitors feel maybe a colder breeze in terms of non-compliance or complaints than they might have done previously. But anyway, just in terms of thoughts for today, you may remember I quoted this man previously, Endo Cunneen. He's the guy who owns the Sunday Business Post. He did a single-handed sailing project where he sailed around the world by himself, and he wrote a book called Journey to the Edge. It's an interesting book, and he talks about risk in the book, and he said the understanding, quantifying and management of risk is a fundamental building block of society and civilization as we have come to know them. And I suppose as solicitors, while we provide legal services, we also, I suppose, manage risk, both risk for our clients and risk ourselves as to how we undertake and discharge our own duties and functions as solicitors. And then in terms of how we're regulated, this book, which is published by Mills, Ryan, McDowell and Burke, Disciplinary Procedures in the Statutory Professions, is really essential reading for anybody who wants to understand the nature of how we're regulated and the implications in particular of not complying with the regulation that governs us. So they say in their introduction, the statutory regulation of professionals is an area of law that is both expanding and evolving. In recent years, 2 trends have been discernible. The first has been the expansion of professional regulation into areas such as the allied clinical professions. So we see the likes of CORU in that regard. While the second has been a process of far-reaching modernisation of legislation governing some of the longer established regulated professions. And from our point of view, that is the Legal Services Regulation Act, which is really, I suppose, can be described as the big bang for solicitors. Now, internally here, how have we responded? Well, we have put in place a risk and compliance unit, and that comprises of myself, Elaine, Attracta and Anna Maria. So we meet regularly, at least once a month, probably more than that in truth, and we have an agenda, and our agenda covers compliance, risk files registers, file maintenance. SARs is compliance with solicitors' accounts regulations, PI renewal in the October-November period, PC renewal in December, January, Q6000, which is our external standard, quality standard accreditation, and any other business. So looking at that in a little bit more detail then, under compliance, we look specifically at anti-money laundering compliance, Section 50 compliance, GDPR and CPD. So every week we generate a printout of compliance with AML and Section 150. And there's a sort of an average picture emerging across the practice. So for instance, at the end of last week, we had 92 outstanding files where there was outstanding compliance with AML and 77 files where there was outstanding compliance with Section 150. So I don't think it's possible for us to reach a situation where those figures become 0-0, because we're constantly opening new files and there's constantly going to be a gap between the time and point when we open the file and when we comply with AML and Section 150. Now, it's obvious when you look at the numbers that the higher outstanding compliance with Section 150 is in the non-contentious area of the practice, so that'd be probate, conveyancing, etc., because there is a week or two at least before the solicitor knows exactly what they're dealing with in terms of the relevant file and what, for instance, the outlays are going to be. So there is that inherent delay in issuing the Section 150. But curiously, the higher level of AML outstanding is not in that section. That happens to be in the contentious side of the practice. And that really doesn't make sense, because in contentious business, the AML should be got at the initial instruction. So I've said it before, it is really important for solicitors at the initial contact with the client, or when they're coming to make when they're arranging the appointment, that they're told to bring AML so that they have it at the first meeting. And that will save us time in terms of, going back, trying to get AML where it's outstanding. And it just makes it a more efficient system. So I think we do on the AML side need to pick up on our efficiency in getting it at the outset. In terms of Section 150 and compliance with that, in terms of not only getting the letter issued, but in compliance with the body of the Section 150, I'll come back to that later. In relation to GDPR, we understand our obligations there, and I think there is an exercise to be done within the practice in terms of how we manage the data, and that, because data requests are going to be part of our future. And in terms of CPD, every solicitor obviously is responsible for their own CPD, but it is helpful if somebody has done CPD to let Anna Maria know, so that we can keep a log, and towards the end of the year assist solicitors in getting CPD where they need to meet their requirements. Then the risk files and registers, then obviously we review those. Complaints, notifications, claims, other risk files, undertakings and critical dates. Just in relation to complaints now against solicitors are presented or filed with the LSRA. If a complaint comes in, if a solicitor becomes aware of a complaint, they should let the managing partners know and copy them with the complaint. And they should also furnish me with a copy of the complaint so that I can update the risk register. So the reality is it's very difficult to get through life as a solicitor without suffering from complaints. And it's not necessarily something that somebody should feel in any way shame or, regret. Obviously, there can be circumstances where complaints on behalf of clients are genuine, but in my experience, in fact, most of the complaints made by clients are not well founded, but they're born out of frustration, maybe lack of communication or lack of understanding of actually the process. So generally they come around issues of communication. But in any event, the complaint, if it comes in, we've got to deal with it. We've got to log it in the register, and we've got to handle it quickly and expeditiously and try and get rid of it. Then file maintenance, solicitors' accounts regulations. There are two parts to that. There's the monthly review of long-standing client balances. So we get a list every month of, it's in an alphabetical order, of our client listings, and we should review that and get files closed, balances paid out where relevant, and the audits that we do then peer-to-peer. I've asterisked those matters because those are matters that do crop up in the Law Society report, not obviously the audit, but an aspect of the audit that I've that I just want to touch upon re Section 152 compliance. So I've put the asterisk in there really as more of a reminder to me. The next then, the PI renewal, PC renewal, and Q6000 and any other business, which I've touched upon. So then risk management procedures. We have the conflicts check that we do initially when we open files to make sure that we're not conflicted. That's very important. We do the monthly client matter ledger printout review then to ensure that's a way of obviously checking files, that bringing files to our notice that we might have overlooked, but also checking that the account side of those files is up to date. And if the file is ready for closing, it goes for closing and any balances are dealt with. And then the peer-to-peer file audits, that's a deep dive which the solicitors do across the practice on other solicitors' files where they fill out an audit form. I'm not convinced that those audit forms are being looked at by the solicitors who have the files, because if they were, some of the issues arising in the law society inspection wouldn't be arising. So I think it's very important not only that the peer-to-peer file audit takes place, but the solicitor who gets the file back looks at the audit and actions the issues that are highlighted in the audit form. So things to look out for then are in the monthly printout is the untransferred costs to make sure they're transferred, long-standing client balances that they're actioned, monies due to client or third parties that they're paid, should the matter be deleted, closed or archived. Now, looking at the long-standing balances and it's an issue that was highlighted in the report, all four issues there seem to be causes: untransferred costs, balances that are just long-standing because there may be a genuine reason, maybe there's a beneficiary missing in an estate or something like that, but maybe there isn't a genuine reason. Maybe the balance needs to be dealt with. Maybe there's money due to a client or third party. And there seems to be an array of reasons, but it's not all what I would call genuine reasons. A lot of the reasons is that the files just have been overlooked and they haven't been closed out properly. And I think the solicitor has to take responsibility for that. It's not enough to say that it's my secretary's responsibility or indeed the account's responsibility. The solicitor has to see the file through to completion and closure. We have a regulatory section or clip on each file, which contains a file opening form, a risk or conflict of interest assessment, a copy of the signed letter of engagement incorporating the Section 150 legal cost notice, copies of the AML identity documentation, including the document your thought process part, and then, if appropriate, details of the source of funds being introduced to practices. Into the practice. So that would be to for instance, buy a house if we're acting for a purchaser, or if we're getting figures like 2, 3, 4, 5,000 euro for medical reports, it would cover that kind of money as well. So it is important. Now, the law society inspection was very complimentary of our policy around all of this, and you know, there is reasonably good compliance with the AML identity documentation. And it seems to me reasonably good compliance with the source of funds and the document your thought process aspect as well. So I think we've made a lot of progress there, but it is very important that we have a culture of having the conversation with the client. Like I had a conversation yesterday with a client who is a Maltese lady actually, and she's selling a house in Malta and she's coming to live here. So she's going to use the money that she gets from the sale of her house in Malta to buy the house here. So there obviously has to be due diligence done on the source of those monies and to ensure that those monies are tax compliant in terms of the jurisdiction from which they originate. So, and that conversation, I had that conversation at the first meeting with her, and she fully understood the reason I was having the conversation with her about that issue. So again, you know, we just need to have the culture of having that conversation. Now, moving on then to legal costs and the new Section 150 regime. We all know that we came from, I mean, there are few solicitors in the practice who qualified pre-Section 68. I think John Duggan and myself might be the only two. And, you know, I remember my father and John Senior trying to get their heads around Section 68 when it was introduced, and I'd safely say my own father never got his head around it. I mean, the idea that you would send the client an estimate in writing of the fees that they were that they were going to pay, or the basis on which you proposed to charge them, was a complete culture shift for solicitors, because solicitors came from a world really where they calculated their bill after the work was done, unless it was prescribed already by scale costs around, which existed for conveyancing and probate, and also for elements of litigation. So it was a real culture shock for them. But you know, that's gone now, and now we have Section 150, which is a further, let's say, increase in the responsibility of practicing solicitors to keep their clients updated with accurate information with respect to legal costs. So what's really important to understand about the LSRA Act of 2015 is it's not applicable to firms, it's applicable to legal practitioners. So you know, that applies to every solicitor in the practice. It applies to every practicing barrister as well. That in terms, when a client comes into the practice, it's up to the individual solicitor to comply with the provisions of the Act. It's not up to the firm. Now, I know if an individual solicitor doesn't comply, then it has implications for the firm. But the primary implication in terms of potential misconduct is for that solicitor themselves. So essentially, Section 150 imposes greater obligations than existed under Section 68. It introduces the possibility of having an agreement with your client around legal costs. However, as we'll see, that agreement should contain, if it's to be instead of a Section 150 legal cost notice, it has to include the component parts of the Section 150 legal cost notice, and also it is subject to review by the legal cost adjudicator. But you would find, I suppose, in relationships between solicitors and commercial clients in particular, where the client is capable of understanding an agreement in relation to costs, and where they're probably paying for the costs themselves, that you know, it allows sort of to create a sort of I suppose, a platform for an agreement around the legal costs where everybody understands where they stand. And you know, I'm not sure if the legal cost adjudicator will stand in the way of that, where there is a parity of, let's say, arms between the client and the solicitor. But that remains to be seen, of course, because the legal cost adjudicator will be adjudicating the cost not only on what's agreed, but also in what's in the public interest. In terms of precedent Section 150 notices, we have good precedents. I think our Section 150 notice is contained within our letter of engagement, and we have a style of letter of engagement for contentious and for non-contentious. I think they seem to be reasonably good. Obviously, you know, depending on the degree to which there is compliance with the Act will depend how each notice is modified depending on the kind of case that the solicitor is handling. But for assistance in relation to the Section 150 notices, there's a very good suite of precedents now published by the Law Society there last year. Consequences for failure to comply with Section 150 is actually misconduct. I suppose there will be shades or degrees of failure to comply or non-compliance, which in terms of sanction or consequence will be dealt with differently by the LSRA or by the ultimately actually by the High Court if it ends up the disciplinary tribunal, or by the High Court. But I suppose that all remains to be seen because it's a relatively new area. I mean, now, I mean, in the past, people ended up before the disciplinary tribunal for simply not serving Section 68 notices. But I don't think we're anywhere close to that. I mean, our compliance in relation to Section 150 is actually good in terms of getting the notices out and indeed getting them signed by the client, even though that isn't part of statutory requirement. It is good practice, and it is something that we're asked in terms of our PI renewal and our Q6000 accreditation. In terms of, do I serve one Section 150 legal cost notice, or do I have to serve a number. If you're doing a piece of work which crosses perhaps practice areas, as the case emerges. So obviously a probate is a simple example where it is a probate and it may lead to a sale of a house or a firm. Obviously, you need to, that's two Section 150 notices. So we just have to be aware that, that we're always complying with our obligations, as it were. So what are legal costs? And this is an important, I suppose, aspect of the LSRA. They're defined as fees, charges, disbursements, and other costs incurred or charged in relation to contentious or non-contentious business. This captures charges for all legal services by a practitioner. So it includes, obviously, if I'm getting a certificate of compliance from an engineer and I'm getting that engineer to provide that, that is a legal cost. It comes within that banner. If I'm getting a report from a doctor in relation to the cost, in relation to a piece of litigation, medical negligence, or any kind of personal injury litigation, then obviously that also is a legal cost. And these items need to be covered in the Section 150 notice. If you don't know what they are at the outset, you should point out you don't know them, but you must advise the client as soon as you do. Now, I say that with a little bit of a caveat, which I'll come to later. Sorry. Now, I'm just going to close out of this temporarily and go to, if I can get it here. It's going on me 1 second. Okay. Can you see that? That's the Legal Services Regulation Act 2015, Section 149. Can everybody see that?
Yeah.
Okay. So just to do a little bit of a deep dive on what we call Section 150. And Section 150 is actually one part of what is Chapter 3 of the 2015 Act, which is legal practitioners' duties in relation to legal costs. So the first section, and this actually is a very important section, Section 149, and that prohibits charging percentage fees in contentious matters. So now that was also obviously prohibited by the 1994 Act as well, but it's restated here. So there's no doubt that we can't charge 10% of a fee of 10% on damages which we recover for a client. The second part is probably the most important part. It says a legal practitioner shall not, without the prior written agreement of his or her client, deduct or appropriate any amount in respect of legal costs from the amount of any damages or monies that become payable to the client in respect of legal services that the legal practitioner provided to the client. Now, that means that you must have the client's prior written consent before you deduct costs from monies you effectively hold for the client. Now, it is absolutely the case in terms of litigation, because it says damages there. But where it says monies that become payable to the client in respect of legal services that the legal practitioner provided to the client, I mean, that, in my opinion, extends to selling a house for a client. It extends to processing a probate as well. So I have the practice in relation to those areas that I get the client's prior consent before the costs are deducted. I also take the view that the prior consent must come at that point rather than at the very beginning of the case. In other words, the client must know what the costs are before they're giving permission to have them deducted. Moving on then to Section 150 itself. This is the point I made previously about a legal practitioner. It's all framed from the point of view of the individual solicitor, the legal practitioner. So a legal practitioner shall, whenever required to do so under this section, provide to his or her client a notice written in clear language that is likely to be easily understood by the client or that otherwise complies with this section. On receiving instructions from the client, a legal practitioner shall provide the client with a notice which shall disclose the legal costs which will be incurred to them in relation to the matter concerned, or if not reasonably practical for for the notice to disclose the legal costs at that time set out on the basis of which the legal costs are to be calculated. So that's fairly clear. It says on receiving instructions. So the issue of the legal cost notice must, in my opinion, be very proximate in time to the receiving of instructions. Otherwise, there is non-compliance. Now, it says a notice shall specify the amount of legal costs certified by the legal practitioner as having been incurred as of the date of the notice provided. Next, certified by the legal practitioner to be of a fixed nature or otherwise certain to be incurred. And 3, insofar as practicable, certified by the legal practitioner to be likely to be incurred. So the key word there is certified. So if I get a house built and I have an engineer supervising the construction, and I ask my engineer afterwards to give me a certificate of compliance with planning permission and building regulations, the engineer is certifying that that's the case. They're giving their professional certification that that's the case. So I think that word is really important. And I think that when it says that the legal cost notice, in our case, the letter of engagement, must be signed by the legal practitioner in the form of a certificate insofar as the legal costs are concerned. And going further, setting out, insofar as practicable, the costs that are likely to be incurred. And I think that that means that in terms of what I said earlier on about the old way being the job was done, that the work was done, the solicitor then would look back on the work and present a bill. Now we're being asked to look forward and actually certify, based on the experience and expertise which we have, the fees that are likely to be incurred. And that includes the outlays, and that includes things like medical reports, engineers' reports. So we're being asked actually to build all this in to the Section 150 legal cost notice now. And, you know, this hasn't been tested in the High Court, but if a solicitor says, well, I really can't say what an engineer is going to charge or what a doctor is going to charge for a report. Well, if the judge turns around to you and says, well, Mr. Callan, a solicitor of your experience would certainly be in a position to give a statement of what they're likely to be. So this hasn't played out yet in court, but I see when a judge is looking at this section in the Act that they're likely to take a fairly literal instruction of what's there and work back from that. So I think even if we're not in that space yet in terms of how we prepare a legal cost notice, I think we need to be moving there. Now, the next piece is about VAT. Well, we know that. The next piece is an interesting one. Set out the basis on which the amounts were or are to be calculated, explained by reference to matters set out in paragraph 2, Schedule 1. Those are the 10 pillars of wisdom. Again, I think this can be your friend in a sense, because if a client comes into you with something that is complex, time-consuming, you can actually set out your legal cost notice by reference to that particular provision in Schedule 1 as a justification for the fees that you intend to charge. And I think that's what's intended by that section. In other words, and this is the public interest side of all of this, if you're charging €300 per hour and you've just said you're charging it by reference to the entire of Schedule 1, well then, what is it? I mean, is that piece of work, is it covered by every single point in Schedule 1? Or, I think if you're going to charge a higher fee for a piece of work that's complex and time consuming, I think you should specifically say by reference in particular to the relevant paragraphs of Schedule 1. And I think then if that bill was ever challenged by the client or came before a legal cost adjudicator, your Section 150 notice will protect you. Then going on, then you've got the piece about litigation. If you're involved in a litigation file, you've got to set out the work to be done at each stage in the process. Again, that is probably guesswork at this stage because you don't know how long the case will go on. But I think you still have to, if your Section 150 legal cost notice is to be, if it's going to stand up at the end of the case, which happens to go to a full hearing, then it will have to have covered the various stages of the process as they will arise. Otherwise, if it comes to taxing a bill at the end of that before legal cost adjudicator, if your cost notice hasn't covered all those areas or those stages in the process, you simply won't tax that, and that's the way it will work. Specify the period which is not longer than 10 days for the purpose of Section 7. That's the cooling off period. Again, you know, I think we probably haven't paid a whole lot of attention to that, but I think for a lot of the work we do, it can be 1 or 2 days because, you know, we've got instructions, we're taking the work. It's only where you know, there will be obviously certain cases where it will be appropriate to provide a longer cooling off period. And I suppose each solicitor will have to take consider that as it arises. Then, in relation to litigation, a legal practitioner shall not, in relation to the matter, engage a practicing barrister, expert witness, without ascertaining the likely cost or basis of cost of engaging the person. Now, again, I think this is really important because I'm not sure it's the practice in our practice that we insist on the barristers giving us Section 150 legal cost notices, because it's as much to protect them in the end of the day as us. Because if I say the bill is challenged and it goes to legal cost adjudication, then if we don't have a Section 150 notice from legal cost notice from the barrister, is the barrister going to get paid? Who pays the barrister? Because certainly the defendant or the defendant insurer won't. So I think, you know, it's really important to understand that when the insurers get a handle on how all this actually works, they may well start challenging bills and relying on technical defences under Section 150 to avoid having to pay costs. Now, is there anything else I just want to touch on here? No, I'll move on just to the next section then. This is the agreement in relation to costs. Again, I have touched on that previously and I won't repeat it. I've already covered that, but there is a provision now for solicitors, legal practitioners to have agreements with their clients in relation to the cost that will be charged, but it must include and comply with a Section 150 legal cost notice as per the Act. Otherwise, you have to serve a Section 150 legal cost notice. And you'll see there, an agreement shall adjudicate in an adjudication of this part be amenable to the adjudication of legal cost adjudicator. Now, then, this is an important one here. And this was highlighted in the Law Society Inspector's report. There was, I don't know where it will lead to, but there was, I suppose, they took note of the fact that there wasn't full compliance with Section 52 of the Act. Now, Section 52 of the Act effectively replaces Section 68(6) of the old Act. So really, there is no excuse for not complying with Section 152, because really it has been the law now since 1994. Other than Section 152 imposes slight further additional obligations on the solicitor, but the principle is the same. So it is important. It says a legal practitioner shall, as soon as practicable, after concluding the provision of legal services in relation to a legal matter for a client, prepare and sign a bill of costs, which shall contain the particulars specified in this section and shall be in the form, if any, as may be specified in the rules of court. Now, this is specifically applicable to litigation, but I think it's actually good practice in relation to non-contentious as well. Subject to subsections 5 and 7, a bill of costs shall contain the following particulars: a summary of legal services provided to the client in connection with the matter concerned, an itemised statement of the amounts in respect of legal costs in connection with legal services, the registration of the practitioner, where time is a factor in the calculation of the legal costs concerned, the time spent in dealing with the matter. Now, that is a new provision that wasn't in Section 68(6). The amount, where known to the legal practitioner, of any damages or other monies recovered, and then the amount of any legal costs recovered by or payable to the legal practitioner. Now, where a firm is sending out a solicitor-client bill in a matter, and you're going to bill the client based on a solicitor-client bill, and they receive part payment only from the third party, you can see here what they're getting at, that you know, the solicitor must show effectively what they have recovered in terms of costs as against what they're charging costs, and there will be a shortfall. And obviously, going back to Section 49, if that shortfall is to be paid for out of the damages recovered, there has to be prior written consent from the client. Now, as a practice, we don't tend to charge solicitor client costs. So therefore, non-compliance to the letter of the law at this section, I don't think will draw too much ire at this point, but it is commented on in the report, and we have to deal with it. What they're saying we're doing in certain cases is we're providing a condensed form of bill, which really is a bill for accounts purposes only, where we're just saying to solicitors fee X, miscellaneous X, and VAT, and then the outlays, which effectively becomes a receipted VAT invoice. That's really for accounting purposes. But so I think when we're preparing our bills for negotiation with the other side, we should be preparing our bills in a format that we can ultimately adapt and then issue to the client at the conclusion and the agreement of the and payment of the bill, so that we're not going through an exercise ultimately to create a bill that we didn't create when we should have created, in effect. So that's just an issue, you know, because I think like the tenor of the report is such that I don't know to what extent it will impact us, probably not hugely, but that's just a guess. But I can guarantee you, if we have a report, if we have an inspection in 5 years' time and we're not seen to comply, then I think we're off to the disciplinary tribunal about this. So, because, you know, we're still to an extent in a honeymoon period with Section 150, because solicitors are finding their way, they're trying to understand it. And likewise, the regulator, the Law Society in this case, and the LSRA are in the same situation. And there's no, as far as I know, there's no cases that have been heard before the High Court yet dealing with any of these issues. But as time passes, that will change. So, you know, I'm just saying to everybody, that's why it's really important that we, you know, that we look at our peer-to-peer file audit forms and we action the issues that are referred to therein. So, so I'm not going to go through the balance of that. I really want to touch the main point about it, and that is the furnishing of a bill of costs in the format that's required. And then this is the dispute resolution. I'm not going to go into that. And then we're on to chapter 4. So I've come out of that and I'll come back into the where I was in the slideshow. So that's so going back, you can see I've touched on the various points that are there. I mightn't have mentioned, but if in the course of a case there's a material change in the nature of the case or matter you're handling, which is likely to affect the costs and the ultimate cost payable, then you must serve an updated legal cost notice on the client. So I suppose that's all kind of what I might call on the, it might sound hard-hitting, but on the regulatory side, what we must do to comply with regulation. But I suppose we need to flick this over and look at sort of how we create a win-win situation for ourselves in terms of the regulation, because it's there, it's the law. Like, people come into us and ask us for advice on the law, and they expect us to give us advice, to give them advice as to what the law means insofar as whatever issue they have that concerns them. So I think they would expect that if there's law that affects us, that we at least understand it and that we comply with it. So just two things then, like going back to Journey to the Edge, Enda O'Connane, he says most people want to change, but don't ask them to do anything different themselves. I suppose we're all like that. You know, solicitors operate in a very high pressure environment. They're under a lot of pressure from clients to get the job done. And there are many obstacles along the way, not of their making, come externally, you know, courts not sitting, barristers being sick and unavailable, doctors and witnesses not turning up, you name it. Like having to manage a file is much more than just simply giving the advice. But, against all of that, we have to be constantly looking at how we make our work easier for us. How do we incorporate, let's say, our compliance regulation in a way that actually helps us fundamentally be a more profitable and better practice? So I suppose the thing is that the most important thing in change is to bring people with you and make it win-win. And that's what he says. And he's absolutely right about that. We got to accept we can't change the regulatory environment in which we live. That's determined by factors way beyond our control. So in terms of win-win, how do we use reputation to, let's say, enhance our reputation and brand? Well, the fact is that top firms never have a problem with complying with regulation. And there's two reasons for that. One is they can afford to put in place the systems to make sure they comply with. But two, and more importantly, they have a culture of compliance. They actually believe, ultimately, that the regulations which the Oireachtas put in place and the laws they put in place are actually in the public interest. And they're there to protect the public. And they actually exist because of misconduct by professionals in the past. And that's the only reason these laws exist, is because people in the past have overstepped the mark. They've stolen clients' money, or they have overcharged them. I mean, we have the case of Declan O'Callaghan and Balhadreen, who is now suspended from practice, has been struck off because there was systemic and industrial scale overcharging going on there. When you looked at his client accounts, they balanced perfectly. But when you drilled a little bit deeper, you found that there was massive, massive overcharging. And that's why I say there is a public interest piece in what solicitors charge in terms of their fees. And that's reflected in the 2015 Act. The second, so reputation, and solicitors only have their reputation, it is their brand. Like the trusted advisor, if we lose that reputation out amongst the client base that we have, then we're toast. So, there is no room for us not to comply with the regulations that are there, or to find ourselves called up before disciplinary tribunals because we haven't complied, because it will affect our reputation. The second win-win piece is, by actually using the Section 150 legal cost notice correctly, you can use it to manage clients' expectations. And it gives you an excuse to discuss actually your relationship with the client around the work you're going to provide for them. What the client can expect in terms of time frame, in terms of contact, in terms of what it will actually cost to do the work. There's a balance between going out and getting work and going out and then doing the work and making a profit out of that work. But where you fall out with the client tends to be around communication and the not matching the client's expectations. So at the outset, the Section 150 notice provides that opportunity. And if a client's expectations of what it's going to cost are off the mark, well, then maybe it's better we know it at the outset than at the end. And lastly, then, we can use it to improve financial management of the practice and improve profitability. So, particularly where we're getting into files where we might be generating like fairly substantial outlays for clients to get medical reports or expert witness reports, the client needs to know what these reports are going to cost. And the practice needs to know whether or not it's prepared to actually fund that for the client. Because, 10 or 15 files with 10 or 20,000 euros worth of outlays is a lot of money out of a bank account. And, fundamentally, there's a viability issue as to how far a practice can go in actually servicing that work for the client, where the client is making no contribution whatsoever. So in other words, the Section 150, again, is a context around which these issues can be discussed with the client at the outset. So again, it's how do we set our culture? How do we manage client expectations? How do we protect our brand? And how do we, first and foremost, make ourselves a profitable business? So that concludes the seminar. If there are any questions, happy to answer them. If I would say going forward, if there are questions that are come across your desk around any of these issues, as they arise, you know, canvass me, canvass somebody in the risk unit, canvass a colleague in the practice, but, you know, share the problem and the challenge, and it becomes half the problem and half the challenge. And we improve then collectively our knowledge of the area and the regulation that applies to us and the culture of compliance that we have. So that in the hope that we build towards a situation where by the time we have our next inspection, that the issues that were there in the past are no longer there. There may be a separate set of issues arising in the future. Who knows what regulation will be introduced? I mean, you know, we live in a fast-moving regulatory environment now, and you know, we can certainly not assume that there won't be significant further regulation imposed on us and indeed all professions. So thank you very much. And any questions, happy to answer them, or at least try.
Thanks so much, Christopher. There's such a huge amount. You've made what isn't always the most exciting of topics quite palatable, though terrifying. I would just like, I think it would be remiss of us not to say at this point, following our very arduous recent Law Society inspection, to thank Elaine and the Accounts Department for the Trojan work that went into doing it. And obviously you're never going to, the Law Society is never going to tell you you're a perfect practice, but it's certainly, you know, a report that for the most part, what we're doing the right thing, and that must be noted as well. It's such a stressful environment that we're all working in, and I think the most important thing is that nobody feels alone. And when we're talking about risk, you're always feeling, you're always terrified. You know, and if there's a complaint against you, or you're subject to, you know, clients, oftentimes you have to remember that people are coming to us not at the best times in their lives. So they're very, very stressed out. And if you're not telling them exactly what they want to hear, they can take great offense at it. But we're very lucky in that we have, you know, we're one of the bigger firms in the region, and we have a huge amount of fantastic colleagues to help and assist us. And always remember, everyone has sat in your chair, and everybody has been worried about something. And you know, a trouble shared is a problem. A problem shared is a problem halved. So I definitely would like everybody to leave home with that message. But thanks so much, Christopher, and definitely I'll probably be having. I think it might be an idea for us to have somebody like Stephen Fitzpatrick come in and really give us. You know, I recently instructed him in relation to a case, and the level of detail that went into, you know, a legal cost accountant's drawn bill of costs, it's really not, it wouldn't be comparable for us to be able to, you know, reproduce that. But there's certainly, you know, it has really moved centre stage, and I think a talk from somebody like that would be well worthwhile. And thanks so much,
absolutely. Okay. Are we done? I think that's a great idea, Niamh. I think that's a great idea, Niamh, to be honest. Yeah.
Yeah. Chris, just one question I have. Just you mentioned it briefly there. You know, Section 152.
Yes.
You know, it's just we never really charge solicitor client. You know, so what level of detail do you need to give in the bill? Is it kind of is it like, as I said, Niamh could have made a good suggestion? Is there kind of a template, or because it's very much a horse trading thing with the state claims, as far as I can see, you know, of professional fees and stuff. So
just 1 second.
Do you need to put in like every hour, or kind of
well, you see, it depends what you're basing your bill on. I mean, in litigation bills, you're basing your costs on a number of factors. Time might be one of them, but to answer your question, it doesn't matter whether or not you're charging a legal or a solicitor client fee. I mean, basically, you're drafting your bill with a view that it be paid 100% by the third party insurer. But that doesn't mean that you don't comply with section 152.2. If you read it, it says you must so it says a legal practitioner shall, as soon as practicable, after concluding provision of legal services in relation to a legal matter for a client, prepare and sign a bill of costs which shall contain the particulars specified in this section and shall be in such form as may be specified in rules of court. So
yeah, I understand that. The
yeah,
premise behind the section, though, you'd imagine will be that the client isn't being shortchanged or, you know, in terms of the money. But I'm just
that's
wondering.
correct. Yeah, that is, let's say, that's the first and like the principal reason is that the client, but underlying it also is that the costs are known to the client, that they're not happening in the background, that they're in some way
I
secret.
understand that. I'm just kind of conscious of the detail, because under privacy contract, they're not really privy if they haven't a solicitor client. Like, once you give how much you're charged and all the outlays and the whole bill, you know, how much detail do you need to explain to the client who's not being charged it from a privacy
Well,
contract?
okay, that's
kind of part of
there's
cost?
one thing, just to correct one thing there, David.
Yeah.
The costs that you recover belong to the client. They're not
Yeah.
your money. Okay. The client, so you're not recovering them. It's essentially, it's part of you recover the damages and you recover the costs. They both belong to the client.
But I'm just, from my point
So
of view,
the issue of privity doesn't come into it. So the issue here is how you go about managing the billing side of this exercise, and it's set out in statute. So a summary of the legal services provided, an itemized statement of the amounts in respect of legal costs in connection with the legal services. So it's you know, if you go back to your section 150 letter, you'll actually have a template for that within the section 150 letter.
I understand. My bills would generally be the same template as any bill in the department, but I'm just saying, is there a need for us to go more detailed? There probably is, Chris. No, that's just kind of I'm only observing.
Well, I haven't seen, I don't
No,
know,
because
I haven't seen.
like, the state claims generally deal with our bills and they're fine, like, but I'm just saying the clients generally would have no problem because they're never charged. But
that's not the point.
No, but I'm not trying to argue the point, Chris. I'm only just saying,
Yeah,
maybe we need some legal cost accountants to tell us what information to put in, because,
I agree. I think that's
question.
I think that is the point.
Yeah.
I
But like
agree.
there is a form, isn't there, specified in the rules of court for a bill of costs?
I understand that, but I'm saying I just think there might need to be a bit more information given the complexity of the medical stuff anyway.
I think that the State Claims Agency are happy to deal with us on the basis of the fee notes that we have been furnishing, but I think this is a regulatory issue, that a higher degree of detail is required for the client, as opposed to the fact in most of our cases the client doesn't really get involved in any of the negotiation. We just send them a copy of the bill once it's finalised and negotiated. But I think under the section, it's a higher degree of detail is certainly required. If you compare what I've just served in one of my cases from Stephen Fitzpatrick and what I would normally serve, and the state claims have never raised any issue about there's not enough details, might ask for timesheets or whatever, but it's definitely a regulatory thing, I think.
Yeah, I'm just wondering, could we get a steer, Chris, as to what information,
you get Stephen Fitzpatrick would be the person to do that, David.
Yeah. No, as I said, I just think of the useful exercise. Because I'm so used to just doing the standard bills. It's something that opened my eyes during the audit.
Can I ask a question? When, let's say maybe we don't charge solicitor client side to the bill, but let's say a doctor charges us €5,000 and we recover €3,500. Who pays the 1,500 differential?
Largely we absorb if
we end up paying
sometimes, Chris, but it's generally not 1,500 difference. Generally they'll pay most of the doctors,
but let's say counsel then.
Coach who insists, and right from the start, that she gets paid the full amount, and the client is made aware of that because they would sign an undertaking about
it. It's a lot easier, Chris, not to charge sister client with medical, because it'll just open up a can of worms for yourself.
Yeah, but to the extent that, let's say, counsel or certain doctors are being paid the full extent of their bill,
Well, council generally they take what they get. Generally, is my
okay.
experience.
Okay.
The only one is Noreen Roach, as Neve would say, but she
Yeah.
insists on it, and the client is to sign an undertaking, or we have to sign an undertaking for it.
Yeah,
okay.
There is. I mean, the stuff that we don't recover generally is just town agents' fees and maybe small differences in some of the medical reports. But generally, we do recover that. And as David said, the barristers will always take just what they get.
Okay.
So, but yes, we are absorbing out of our fees any of those differences if there's differences.
Yeah.
For the most part.
But like your miscellaneous outline scrivenery, because they'll nearly mop up that, like, no, like.
Yeah, well, I suppose it is a regulatory issue as matters stand.
Yeah.
I think the issue that will arise in the future is when bills are being challenged and they come before the legal cost adjudicator, how they will be dealt with if there's non-compliance with the initial legal cost notice, and indeed if the bill of costs when it's ultimately furnished doesn't comply. I mean, that's where I see. I mean, I kind of see it ending up there ultimately, to be honest. I mean, it's early days yet, but I think, that's where it's going to go.
Yeah, I just think I'd agree with Neve. We probably need a bit of more education on our bills, I'd say. Well, I do anyway.
I say, like, I think it's a great idea to ask Stephen Fitzpatrick or somebody like that to help.
Yeah. Now that we can do it by Zoom as well, you're not asking him to, like, travel down to Sligo or something like that. And we'll see if he can do it. I'm not necessarily saying him, but I think he's excellent. And also, he can recover the costs of preparing the bill. That's a new thing that has come in now, that the costs in the preparation of the bill are recoverable. So we're recovering 80% of his fee, which is excellent, which is a new departure from before, when you couldn't charge for preparing the bill. So that's excellent. And
I would go for him if he'd do it, Neve, because he sits on the board of the LSRA.
Well,
so like when the LSRA are going to be kind of formulating a view on this from their perspective, he'll be informing that view.
Great.
Yeah.
Okay. Is that everybody? Does anybody else have any comment to make, or can we leave it at that?
John Duggan, are you still there? He has his hand up here on Teams. Maybe did he want to say something? No.
He's muted. He's muted.
Yeah, but
he's muted, I think.
Yeah, no. Yeah. Sorry, it was to do with that David's query there. I was just, I think it's been dealt with. There is only one bill of costs. I remember some legal costs accountant telling us that there's only one bill of costs, and that's the client's bill of costs. Mm. So, I mean, that's the basis of why you have to comply with Section 152, because there is only one bill of costs. Essentially, your bill to your client is the bill. Now you're getting a fund from the other side to discharge. The client is getting a fund from the other side to discharge some or all of that bill of costs. So I think that's why you have to set out the detail required by Section 152, because it is the client's bill of costs. It's not the State Claims Agency bill of costs. There's only one bill of costs. Is the
yeah.
That's all.
Just looking here at where we don't generally provide that bill to the client at that point. Just wondering, does it? Something I just need to check whether we're obliged to do so or not. I'm not sure.
The client with the bill, that my first bill, and then what I've negotiated with the other side, so that they see, even if we're not charging solicitor client, or if we're not looking for the shortfall to be recovered, so they see exactly what we recovered as against what we, they have the bill. I think you have to send the bill always to the client.
Is that is it the omnibus bill or something that I do see on files that you send what we got from the other side, and then if there was any solicitor client, is that what that is, Neve?
I mean, you've, as John was saying, you've only one bill of costs, and you send out your first bill that you send. Well, this is maybe we should have streamlined it, but my practice is I send out a bill to the other side. Obviously, look for a bit more than I know what I'm going to get, And then when at the end of the conclusion of the negotiation, I cross out what I charged in manuscript, and they see what I recovered in respect of everything.
Yes, yes.
And that they know that that's what our bill of costs was, and this is what we recovered. And if there's a shortfall, and that they have to, you know, if there is a shortfall, that generally we don't recover the shortfall in our professional fee, but sometimes I would recover the shortfall for other miscellaneous item, you know, reports, etc. But I think you have to send that. That's my practice, so that they know that
that's section 52(1), Niamh. That's what it says you've got to do. But the point is, you've got to set out the full detail of the services provided to the client, and that. But that is what section 152(1) says. Like, that's the thing. Now, what I was kind of just musing in my own head there was that when we prepare the bill and we send it to the insurance company for negotiation, really at that stage it's probably not a bill of costs as such, and it's more a bill for negotiation purposes. Because ultimately what we're saying is that our bill of costs is going to be fundamentally whatever we agree with them.
Absolutely, but definitely I don't set out the detail that I would in a case where if the client is actually paying me, for example, if I was doing a non-litigation type work, I would set out absolutely everything that I've done on that. But
that's what you got to do here now.
And in the litigation cases, I haven't been doing that.
Yeah.
But the State Claims Agency haven't raised it or whatever. But now there is a new provision on that. I'm obviously not the expert to speak on it, but Stephen Fitzpatrick has said that you are entitled, because obviously that's a huge amount of work will go into preparing that bill of costs and detailing all of the work done. You are now entitled to get paid for that as well. That's a new departure, he has said to me. Like,
yes, because that's part of the work in relation to the file.
Yeah.
But the fact that the State Claims Agency doesn't raise an issue doesn't really matter, because it's more to do with the fact that when we're in our inspection, what they're saying is what we're doing is we're issuing the client with kind of condensed formats of bills which don't comply with section 152, but it's not in a sense, like, because the client isn't paying there isn't any element of solicitor client charge over and above what we're recovering. The client isn't at any particular loss, but still technically it doesn't comply with the Act, and that's what they're saying.
Yeah.
Christopher.
Yeah.
So couple of points there. John is absolutely correct. Like, it's the single bill. So when we say the level of detail is in the same way as when you go through your bill and you might have things like outlays, or you might have miscellaneous outlays or town agents fees, and you put in town agents fees into your bill, and when you send it across to the other side, it's hit and miss as to whether or not the other party will discharge those. A lot of them will say that's a solicitor client matter, so they're not recoverable on a party and party basis. And that's fine. But that's the kind of thing that still needs to go into the bill, for the simple reason that the bill is the client's, and the bill is sent across to the other side is addressed to the client. It's not addressed to the party to whom the bill is being sent. So the level of detail simply needs to include in the narrative, not in the discrete items, but in the narrative for professional fees and services. It needs to include both items which have been accrued on a party-party basis, but also work you've done on a solicitor-client basis. So it will include things like the consultations with the client, which will not be recovered on a party and party basis. So there's full transparency. The other side says, well, you had 4 consultations there with your client, you've put them in, we're not recovering them. That's fine that you don't recover them on a party-party basis. But the benefit for you as the solicitor is that you then show that to the client to say, we incurred these, and you are entitled then to recover them on a solicitor-client basis.
Yes, spot on, Brian.
Solicitor-client bill is the shortfall. You have your full bill, and then you get a contribution, as has been said by John, or not a full indemnity, but usually a contribution. And I think most of us are experienced enough to know that you get about 80 to 85% of your costs back, all going well. Sometimes you do really well and you do better, sometimes not so well. It's a separate decision then for you as to how much of that shortfall you collect from the client. Now, you can factor that into the settlement authority by saying to the client that if the shortfall, if the amount that we recover overall is less than the anticipated shortfall, so if we hold back 15,000 and we only get, and there's 10,000, the client still has to make up 5,000. But if we hold back 20,000, but the shortfall turns out to be 15, we give the client the 5,000 excess. And that can be built in just as a single line in the settlement authority. So you're completely covered then when it comes to it. But it is a question of choice as to whether or not you want to charge a solicitor client. And depending on the type of client you have, and maybe there's some difficulties with that client, you just might decide it's just better not to start going into that because they can be difficult and start asking questions. But it can't be a case that you think that you're charging solicitor client as a kind of a premium on your fee or as a top up, which I think is what landed our friend in trouble, is that there was a certain amount that he was okay with, and then he just decided to lob on another 10 or 15% for sort of whatever lifestyle he wanted to fund, you know.
That's it in a nutshell, Brian.
Yeah. So, there's 3 people still awake.
So are we?
We're all here, Brian.
We're all here. We're all
Present and correct.
We're all good.
Present and
Anyway,
correct as
yeah.
well.
Excellent, Christopher. Thanks a million anyway for
Thanks,
that.
Christopher.
Okay.
Thank you.
Okay, you're welcome.
Thank you.
All the best.
Thank you.
Bye.
Thanks.
Bye.
Bye.
Thanks, Christopher. Bye.
Bye.